Too many things. Okay, there. So that intro is pretty standard. No big deal that we missed it, but I'm going to turn things over to Marissa Jimenez and Alejandra Perez Orozco from Bay Area Legal Aid to do our training today.
Good morning, all. Thank you so much for making time on a Monday to be here with us. My name is Alejandra, and I will be co-presenting today with my colleague Marisa. We are both attorneys at Bay Area Legal Aid. Marisa, did you want to introduce yourself or say anything else?
Yeah, I would just like to say good morning to everybody. Thank you for being here. And I apologize, I'm having some technical difficulties with my camera this morning. So I will be a disembodied voice, but I am here with you in heart and soul, okay?
Just to start off, I wanted to share a little bit more about what Bay Area Legal Aid provides. To let you know, we serve in our 7 surrounding Bay Area counties, and these are the topics, basically the area of services that we help in. I'm not going to go through all of them specifically, but you will have these slides. I know you got some this morning, and you'll get them again afterwards. In case you ever have questions of what services, you can connect anyone you serve with to us. But I specifically work in the housing unit, so does Marisa, and we would specialize in the areas listed here. So housing, eviction defense, fair housing and discrimination, and subsidized housing issues. In terms of our client eligibility, just important to know that we require that our clients live in one of the 7 counties we serve in the Bay Area. And then there are some additional requirements around immigration status, as well as income-related requirements, where our clients generally have to be under the 200% line of the federal poverty line, unless it's health-related work and they're coming to us with questions related to healthcare access. How can you reach us? This is a very important point that I make sure I share with folks who I'm reaching. We have a legal advice line that's open. I listed the hours here. And I wanted to let you all know we have a new line dedicated to Contra Costa County, also a toll-free line. It's available during the same hours as our legal advice line. But we wanted to list those here for you in case you want to refer people you are serving to us. This is the best way to do it. I always recommend that if folks are having trouble accessing the line, they call specifically during the hours that we list. So for example, a lot of folks tell me I wasn't able to reach you over the weekend. Unfortunately, we're not open on Saturday or Sunday. But to that end, if you're calling during the hours, to call as early as you can, as close to the opening time of 9:30. Today we're going to be talking about fair housing laws and protections, which cover not just federal law, which there are federal fair housing laws that protect us from housing discrimination, but there's also state law, and we're going to be delving into both to look at the protections that exist for people in housing. And I want to just highlight what the purpose of fair housing law is. And I'll just say for housing laws because there's more than one. But it's essentially to prevent discrimination in housing by making it illegal to disadvantage someone in renting, buying, or occupying a home because of that person's membership in a protected class. Now, the obvious question here for us is what is a protected class? So, under federal law, the federal laws that we looked at in the earlier slide have definitions around what's considered to be a protected class. And so, if you're a member of a protected class, either because of race, color, religion, sex, familial status, national origin, or because you have a disability, that's a protected class under federal law, which means that if it's related to housing, a housing provider could not discriminate against you based on your membership in one of these groups. Now, under state law, and this is a little bit about how state law works, the state law can provide additional protections on top of, let's say, the baseline protections that federal law covers. So California law includes everything that we just read under federal law, plus all these additional categories, which we'll talk about in a little bit finer detail, but this includes marital status, ancestry, sexual orientation, gender expression or identity, source of income, medical condition or genetic information, veteran status, as well as primary language or immigration status. And we're going to share examples about what this looks like and what this means, but I want you to know that the key takeaway here from this slide is that California provides us with additional protections on top of what federal law provides us. What do fair housing laws cover and how are folks protected? I do want to explain that fair housing laws cover all aspects of the housing process. So this could be that it starts with a listing advertisement. This could also include the application process, screening, the conditions of a tenancy, all the way through when a provider, let's say, is seeking eviction or termination of the tenancy. So really, we're looking at a lot of the start to end of what housing services can look like. It also includes lending, just to say. And what is the prohibited conduct? And another way to think about this is, what does fair housing law recognize discrimination looks like? And under the law, today's law, intentional discrimination is prohibited. And what does that mean? It means when somebody in one of these protected groups or a person associated with one of those protected groups is treated differently because of that association or membership. And this difference can be an intentional treatment, like somebody says something to you or somebody writes something to you. Additionally, and we're going to focus a little bit more on this area, there's something called disparate impact. And what the law basically says is that the law believes, that a conduct that is neutral on its face but results in a discriminatory impact of a protected class is in itself discrimination. And we're going to look at a number of examples around that, and I'm going to provide you some updates to that particular idea. Additionally, what's prohibited around discrimination is sexual harassment. So if you're in housing and you experience a hostile environment that creates that sexual harassment is part of that hostile environment, or where you're being asked to do something in exchange for, let's say, sexual favors, that is additionally covered, as well as vicarious liability, which covers, let's say, employees of your housing provider who may be engaged in sexual harassment. And that's considered gender discrimination generally. Now, additionally, another topic that we're going to look at that I want you to keep in mind that's prohibited is discrimination against domestic violence survivors. Now, just to get us all going, we're going to do a hypo here. It asks this question. I don't want folks to get nervous. After having been in school for so many years, whenever I see a multiple choice question, I get a little nervous. This isn't about getting nervous, it's just about us having a conversation. I'm going to read this out to you all and give you time to read it yourselves. But Tracy Tennant lives in a large apartment complex in Walnut Creek. She lives in her apartment with her 2 children. And the landlord tells her that children are not allowed in the laundry area at any time. Imagine you're living in an apartment complex with your children, and the landlord tells you, hey, by the way, your children are not allowed in the laundry complex at any time. Can the landlord institute this rule? And please put in the chat if you believe the answer is A, yes, the landlord has a right to control the common areas. If the answer is B, no, this qualifies as familial status discrimination. Or C, yes, because this is not discrimination based on a protected class. What do folks think is the correct answer? I'm seeing a good mix, but overall Bs. Thank you all for sharing. I want to make sure everyone has time to weigh in. As you're thinking about the answer, I will say that it is very common to see rules like this just in everyday living, and this is something that I wouldn't be surprised if it's something that's happening in your neighborhood or with your clients. And I'm here to tell you the answer, and that's no, this actually qualifies as familial status discrimination. And what does that mean? It means that under the laws that we looked at, you can't be treated differently because you have children. Certainly, there are things that your landlord can keep in mind around safety, but wide, broadly stated bans like this one are likely to be impermissible under the law because they particularly target folks who have children and prohibit them from having access in the same way as others to, for example, common areas like the laundry room. So thank you all for weighing in. And let's move on to our next slide. So as we said before, we're going to delve into examples around what discrimination is. And so, what are some examples of intentional discrimination? So, it could look like outright telling you or writing to you with a refusal to rent, sell, or lend to you because you are a member, again, of a protected group under the law. Or it could look like discouraging someone from applying because, again, they are a member of a particular group. Like, let's say someone is discouraged to apply to a complex because they are in a wheelchair and this complex has a pool and stairs and things like that. So that's definitely not permitted. Requiring different rental terms or rules for some people than others based on their membership in the protected group. Or it could look like enforcing, segregation through advertisement steering or physical separation. Again, this is the idea that when you're applying, somebody could look at you or decide, based on what I believe you are, we're going to send you to this listing or suggest you should only live on a particular floor. Um, this could also look like responding differently to requests for repairs. Commonly, this could be, oh, because you're a member of a certain group, we're gonna delay completing repairs or not complete repairs at all, or complete the repairs of some folks but not other folks because of differences in who they are. This could also be treating applications differently, right? So these are just some examples of things that could be considered intentional discrimination that's not permitted under the laws we're talking about. What are examples of disparate impact, right? Earlier we said that disparate impact looks like a neutral policy that doesn't particularly target anyone, but that its outcome tends to have a result that impacts certain protected classes and not others. That's harder to think in the abstract, but when we look at examples, it starts to make a little bit more sense. So, for example, having a policy to evict tenants who call 911 more than twice in 6 months. Let's think about how that looks like. If you are, for example, domestic violence survivor who needs to call for emergency services, and let's say it happens more than twice in 6 months, that could disproportionately impact you or other domestic violence survivors. It could also look like a policy requiring tenants to come to the management office to do an annual recertification or reexamination. Why would that be creating a disparate impact? That could be creating a disparate impact on folks with a disability who may not so easily be able to come to the office, right? Again, it's not that these policies couldn't be implemented necessarily, at least when we're talking about the second one. It's that it shouldn't be a blanket ban and should really consider various needs of different tenants so that people can access the same services with adjustments, right? Policy that limits the number of occupants per unit. Again, this is interesting because there are some guidelines around how many people can live in a space based on health and safety standards, occupation standards. But on the whole, if let's say a family moves in and they have more children and they're told, no, there's a limit to how many people can live in the unit, that could be familial discrimination, right? Familial status discrimination. A policy that requires prospective tenants to prove they are employed full-time, right? On its face, that seems neutral, like you should have a job to be able to live here, but in practice, that could impact certain groups of people differently than others and prohibit them from having access to that housing. So, for example, if you're a person who has a disability and actually receives disability-related income like SSDI or SSI, then you wouldn't necessarily be employed, but certainly you would be excluded from this policy because you are not employed full time. So again, this is the idea that there could be a neutral rule that exists that applies to everyone, but certain people who are part of protected classes are particularly affected. And I want to share this example because there's an update around this area of discrimination that I want to share with you all. And the update is that back in April 23rd of 2025, President Trump issued an executive order that had the goal, and I hyperlinked the executive order here in blue. So if you want to click on this link on your slide, it'll take you directly to the executive order so you can read it if you're curious. But essentially, from the executive order, it says it seeks to eliminate the use of disparate impact liability in all contexts to the maximum degree possible to avoid violating the Constitution, federal civil rights laws, and basic American ideals. And what does this all mean? Essentially means that through this executive order, the president has directed the executive and all of the folks who basically have been created under the executive, including administrative agencies, like, for example, HUD, to tell them we are no longer enforcing this form of what the law has established as discrimination. And so, what I want the takeaway from here to be is that the law still exists, right? Disparate impact is still believed a form of discrimination. But President Trump has directed all executive employees and agencies not to enforce it. And so this can look a number of different ways. Effectively, through this order, they can direct the federal government to, for example, assess all pending investigations where the government, the federal government is a party, lawsuits and consent judgments that rely on disparate impact to prove discrimination and to essentially invalidate them. And so we'll talk more about this, but what that could mean is, let's say you are a tenant who believes they've experienced discrimination, and we'll take the example of domestic violence, where maybe there's a blanket policy in your housing that says you cannot call emergency services more than twice in 6 months. And you do, and the property management or the ownership starts an eviction process against you because you didn't comply with this policy. If you believe that's discrimination, and under existing rules, that would be discrimination, right? Potentially under disparate impact theories. You file a housing discrimination complaint with HUD, right? And this is the basis why you're saying I was discriminated, because there's this neutral policy that impacts me in a different way than other folks as a domestic violence survivor. At this time, the administration would direct HUD not to enforce that rule. So they could dismiss your claim if there aren't any other bases to believe you were discriminated. Right, so we'll talk more about these examples, but I want you to keep this executive order in mind if you're curious about how it's impacting things. You can always look up the news and look up disparate impact to see news stories around how it's being reported as an impact. And this sort of transitions us into talking about domestic violence survivors and fair housing laws that exist for them. This is a quote that I found helpful from a past HUD Deputy Assistant Secretary that essentially says, look, domestic violence survivors experience housing discrimination, and they experience housing discrimination based on their history or the acts of their abusers. And sometimes this can look like, for example, zero tolerance crime policies, where telling the household, you have failed to comply with our policy against zero crimes, and everyone in the home could be evicted, even the domestic violence victim or survivor. They could be, again, using the same example, evicted after making repeated calls to emergency services after domestic violence incidents. They could be evicted because of property damage that has been caused by their abusers. Or, for example, they could be punished for the violence that's been inflicted upon them, right? Now, as you can imagine, under existing fair housing law protections, some of these things would probably not be legal, right? Because they again would violate these protections that people have under the rules that we're talking about. So I just want to highlight this in a different way to say that, for example, certain policies that, like evictions or terminations based on violence against survivors, may violate our fair housing laws, as we're saying. Policies that, for example, are based on gender stereotypes, which I have seen in my work, where, for example, an owner says they're evicting a woman with a history of domestic violence because, quote, they always go back to the men who abuse them and they don't want to continue, quote, dealing with this. That in itself would be considered housing discrimination. Again, the idea is that the protected class is gender, and this stereotype is being used to deny housing services to someone who's protected. And again, treating survivors differently because of their status as a victim of DV. Now, when we're talking about what are the specific protections that domestic violence survivors have, I want y'all to know that there are rules, right, still on the books, that, for example, exist to protect certain individuals who face these life challenges, we'll call them. For example, under VAWA. What is VAWA? The Violence Against Women's Act is a federal law that's intended to encourage survivors who are receiving a housing subsidy from the federal government to report and seek help for the abuse against them without being afraid to be evicted. Really important to think about what its purpose is. And so essentially, it protects an individual who is applying for or living in a federally subsidized place from being discriminated against because of these very things we talked about: acts of domestic violence, sexual assault, dating violence, or stalking. And it applies to survivors, at least on the books, regardless of sex, gender identity, or sexual orientation. Now, again, this is specific to folks receiving federal fair housing subsidies. Um, to go into some of the definitions, it is important to understand that under these laws, everything is defined. So, for example, domestic violence has this particular definition. So does the dating violence, sexual assault, and the stalking that is covered. And it's important to know that these particular protections apply not just to the tenants living at the unit once they're there, but also to applicants. So if something happens to an applicant, that would also be covered. And I just want you to have reference to these definitions. There's no expectation that, you can memorize them or anything like that, but these are in the slides in case you're wondering what it covers. Big picture, VAWA protections include rights around having the locks changed, having a right to break the lease early without penalty, Right to protection from eviction. Again, the idea is that you shouldn't be evicted for things that we talked about could be of a particular impact to domestic violence survivors. And the housing provider has a duty to provide safe housing, which could mean a duty to provide an emergency voucher to move someone from one housing to another. But there is uh, grounds to evict if a housing provider, a federal housing provider, can prove that there's an actual and imminent threat to other tenants or employees if the survivor's not evicted. And so, what does that mean? Again, the definitions are really important. And when we're looking at what is actual and imminent threat, we look at the regulations that HUD has made to see what level of proof and definitions are required to meet those factors, right? And so I listed what some of those look like here together with the citations to the Federal Code of Regulations to understand, for example, what that could look like. And to highlight, so for example, an eviction should occur only if there's no other action to be taken that would reduce or eliminate the threat. So it's not just very simply that there is a threat, but that really all these things are true. Um, Now, important to know, like we said before, while there are protections under federal law, we also have additional protections under state law. And I wanted to highlight some of the California protections for survivors that apply to folks living in the state, right? So there is a new right to have the locks changed, and an update that I want to share with you in the next slide. There's a right to break the lease early, which is effectively a 14-day early lease termination notice that a survivor can give. And this is whether somebody has like a year lease, they're in the middle of their lease, or if they're month to month, they would just need to give a written notice of 14 days to terminate their lease. The good thing to know about that is you don't have to wait 14 days to move out. You can move out immediately, but what it does is it cuts the time that you are responsible for paying for. So you really are only responsible for much less than what is normally required if you're breaking the lease early. And then you have right to protection from eviction so that a housing provider could not terminate you based on acts of domestic violence. And I wanted to delve a little bit deeper into the new protection under California law to change locks. So previously there was a right to have your lock changed, but it wasn't clear that it was the landlord's responsibility to pay for it. So in this case, the landlords have to change the locks within 24 hours notice at their own expense when provided with proper documentation from tenants. And the proper documentation can be one of many things, including a restraining order, police report, or statement from qualified third parties, which can be a whole host of providers. Um, if the landlord fails to act within 24 hours, tenants can change the locks themselves and have to be reimbursed within 21 days. They do have to provide a copy of that key to the housing provider. And that's the tenants have to provide it to their housing provider if they change the lock. Um, and then importantly, landlords cannot deny housing or take negative actions against tenants or applicants based on their status as victims of abuse or violence, which again is sort of a reaffirmation of protections under California law that's just helpful to see and know are existing today as of a current law change for folks we may serve. And then we have our next hypo. So again, we're just going to read through this together and see if we can effectively apply some of what we're learning. So Tessa Tennant lives in subsidized housing in Antioch. On September 1st, she was attacked by her abusive partner in the front lobby of the apartment complex. On September 3rd, her landlord serves her with an eviction notice for the altercation in the lobby. Can the landlord evict Tessa under these circumstances? A, yes, he can evict her because the altercation is considered a lease violation. B, no, he cannot evict her for acts against her that constitute domestic violence. Or C, it depends on whether her housing is covered under VAWA. So what do you all think is the case here? Thank you all. I'm seeing lots of bees here. Lots of bees. The day of bees. And I'll give you just a couple seconds more to think through it. And yeah, so it is B, so that's right. No, he cannot evict her for acts against her that constitute domestic violence. Here, it's very clear that he gave her a notice very soon after the incident, and it was likely related to the September 1st event. Thank you all for weighing in on that. And so now we're going to transition into protections for disability under the law and what disability discrimination protections look like. So under the Fair Housing Act, which is our federal law, it's against the law for a landlord or property manager to ask about disability unless a tenant is requesting an accommodation or applying for housing that gives priority to persons with disabilities. It's also not permitted to discriminate in housing due to a person's disability. We talked about some of these examples in the beginning. For example, not allowing someone to apply or steering them. It is also not permitted to refuse to provide a reasonable accommodation for a disability unless certain exceptions are met. And it's not permitted to ask a tenant to provide more documentation than what is necessary to verify disability or a need for accommodation. And it's also not permitted to ask a person with a disability to prove their ability to live independently. What are some examples of intentional disability discrimination? So, like we mentioned before, one thing that's very clearly not permitted is steering, right, to a certain building or to a certain floor based on disability or even perceived disability. So, for example, oh, you don't want the unit by the pool because it's noisy, and in fact, you won't use the pool anyway, right? That's not permitted. Again, the idea is that you are being treated differently and are not being permitted to access housing that's being provided in the same way as others because you're a member of a particular group that happens to be protected under the law. Now, it could also be that there are different terms or conditions or privileges that are being given to some and not others. And so this could look really in many different ways. It could be a higher deposit for a motorized wheelchair, but not a manual wheelchair, or walkers or canes, or just simply saying things like no wheelchairs are permitted in the lobby. All those things would be things that could be considered disability discrimination. When we talk about protections, it's also important to understand, especially as we provide services to folks and may ourselves also be tenants, that you have a right to request what's called a reasonable accommodation. And the idea is that reasonable accommodations allow people who live with disabilities to access the housing accommodations in a way that meets their needs. And so another way to think about it is that it's a special request that seeks a change in a rule, a policy, or a practice, or even a service that's necessary to allow a person with a disability the equal opportunity to use and enjoy the dwelling. Now, the important thing is that the request that you're making has to be related to your disability need. And in the way that we talk about this under law, we call that the nexus. So whatever you're requesting has to be related to the disability need that you have. But disability means, at least under federal law, mental or physical impairment that substantially limits one or more life activities and or a history of such impairment and or regarded as having such an impairment. And these things are really specific, but I want you to keep in mind that the California law does not require that it be a substantial limitation. It can just be a limitation that affects life functions. Why is this important? What does it mean for us? It means that it may be the case that you have a tenant that you're working with or a client that you're working with that has medical needs that can be considered a disability or a disability. And the reason that I make that distinction is because a lot of times when I talk to folks who I'm helping and I say, hey, do you have a disability? A lot of the people I talk to will say, no, I don't have a disability. I'm perfectly fine. I can walk. I can still work. And then I ask some more questions and I realize, yes, they may have a medical need. It could be related to depression, anxiety. There's a whole host of medical things people can experience that affect their daily life that may be affecting their ability to access some service in their home that they may be seeking help. So sometimes it's easy to see these definitions and not understand how they apply in our daily work or how it impacts people living in their homes. But I think thinking about how it can be not just what folks may think is a disability, but it could be more about a conversation around their physical medical needs, then we can start seeing how this particular request could be useful for them and how they're accessing their housing. And then the last thing I'll say is sometimes it is very helpful to speak with an attorney about these issues. If you ever need to refer folks with questions around these issues to us, please do, so we can have conversations with them about what their options are. And then here we're going to switch over. Thank you all for your time. Just to reiterate, we're going to take questions at the end, but now my colleague Marisa is going to take over and share the rest of this information with you.
Thank you, Alejandra. So we're going to continue talking about the reasonable accommodations and how to request a reasonable accommodation. It may be requested verbally or in writing. We strongly recommend that the accommodation requested is in writing, even if the initial request is verbal. That way you have evidence of what you requested and the date, etc. A reasonable accommodation, as Alejandra said, must have a nexus to the disability requested. And that means that the accommodation must be connected to the disability and be necessary for the person with the disability to use and enjoy their housing. So let's look at some examples here. For example, it would be challenging to prove a nexus between someone with a hearing impairment to request an assigned parking spot close to their apartment. What would be the connection between the hearing impairment and the need for an assigned parking space? On the other hand, a person with a mobility issue and the need for an assigned parking space closer to their unit, the nexus could be that it's difficult for this person with the mobility impairment to walk, and in that way, the connection between the disability and the requested accommodation can be seen. If a housing provider believes that the requested accommodation is not reasonable, then the housing provider and resident are supposed to engage in an interactive dialogue, a negotiation. It may be considered discriminatory if a housing provider denies a reasonable accommodation, or if the housing provider denies a resident a reasonable accommodation. the resident has the ability to seek enforcement of fair housing laws through HUD or the California, at the state level, the California Civil Rights Department. When can an accommodation be denied? Under state and federal law, thank you for that slide. Under state and federal law, a housing provider must provide a reasonable accommodation unless the requested accommodation has no relationship to the person's disability, or if providing the accommodation would fundamentally change the nature of the provider's operations, or it would impose an undue financial burden or an administrative burden, undue administrative burden, or if it would create a direct threat. So again, let's talk. If the housing provider believes that the requested accommodation is not reasonable, the provider is required to engage in the interactive dialogue, the negotiation. This will allow the provider to receive more information about the disability-related need and to hopefully find a reasonable alternative accommodation. Additionally, additional info on reasonable accommodations are that a request for a reasonable accommodation does not have to be in writing, and knowledge by the housing provider of the need for an accommodation may be enough to trigger the responsibility under Fair Housing Act. Again, we do strongly recommend that the request be in writing, but this is interesting to know that it could be enough just that the provider knows of the disability that may trigger the responsibility to provide the accommodation. Verification of disability does not have to come from a doctor, and medical privacy rights are still enforced. A failure to respond to a request for reasonable accommodation is a denial. That would be an opportunity to encourage the housing provider to come back to the table for negotiations and the interactive process.
And I'll just jump in with this slide on emotional support animals. This is a really common question we get in our work, and there are some distinctions under California law around service animals. And so I want you to keep in mind that there's a service animal, and then there's an emotional support animal, and then there's a pet. Generally speaking, landlords do have the right to create pet policies around what is permitted. However, under California law, they have an obligation to have to consider if an animal is related to a disability related need. And for example, with an emotional support animal, the definition under California law for one is really an animal that provides emotional, cognitive, or other similar support to a person with a disability to assist them in managing the symptoms of their disability. And I want you to keep in mind that with emotional support animals, a landlord can basically allow this emotional support animal to live with the tenant through a reasonable accommodation request. And in that act of defining this animal as an emotional support animal and creating a process by which they can be approved through reasonable accommodation request, it carves an exception within a pet policy where this animal would not be considered a pet, subject to, for example, pet fees or blanket bans. And basically they have to be permitted to be approved unless the housing provider can show that it would create an undue financial or administrative burden, that it would be a fundamental alteration to the housing provider's business, or that it would pose a direct threat to the health or safety or others, or that this would cause substantial physical damage to the property, or that the harm couldn't be sufficiently reduced or eliminated by a reasonable accommodation. The key takeaway here that I want folks to see is that blanket bans are what are likely going to be impermissible under the law. There have to be sort of exceptions made for emotional support animals through a reasonable accommodation or service animals otherwise, that allow persons living with disabilities to meet their needs through having one of these categories of animals. So again, we're looking out for the blanket bans, which are likely not permissible. There should be room to be able to provide, for example, reasonable accommodations or otherwise to allow emotional support animals. And as a side note, I'm sorry I forgot to mention this at the beginning, but with your materials today, you should have also received some fact sheets that were provided, or they were made by the California Civil Rights Department around some of these topics that we'll be covering. And I included some of the fact sheets that have things, for example, there's an emotional support animal one that's a frequently asked questions list that has a lot of really good information if you want to share those with the people you are serving or if you yourself have additional questions around these topics. So I encourage you to take a look at those resources because they have a whole host of really valuable information. And with that, I'm passing it back to Marisa. Thank you.
Thank you. We're at the 1 hour mark. Are we going to take a break?
Yeah, I think that sounds like a great idea. We could all use a break to do the things. How about, Jamie, are you okay with about a 7-minute break?
Sure. I
Okay.
will time it and I'll make some noise when it's time to come back.
Yeah, so we'll be back at 11:07, folks. Please feel free to take a break to do what you need to do.
Thank you. All right, good morning. I'm no longer a disembodied voice. And we're back from the break and we have a hypo. Here, Tracy Tennant is searching for a new apartment. She finds a place she likes because it's near her job and a dog park. She plans to get an emotional support animal once she moves. However, when she spoke to the property manager about the listing, they told her no pets are allowed and they make no exceptions. So, can the landlord institute this rule? Yeah, the options here are yes, the landlord has a right to implement the pet policies. That's option A. Option B, no, this qualifies as disability discrimination. Option C, yes, because this is not discrimination based on a protected class. What do you all think? All right, seen lots of B's and a couple of other options. All right, answers still coming in. Looks like a lot of B's. Someone says she's not disabled. That's interesting. Yeah. All right, it looks like the majority chose option B. It depends on how she framed her request. Yeah, still more answers coming in. This is great. So yes, the answer is B, that the landlord would not be able to institute this rule. It qualifies as a disability discrimination. So the wording from the property manager says they make no exceptions, and that's akin to a blanket denial for anyone. And I think the point brought up that Tracy is not disabled, I think it's a good one. You know, in the hypo, it says that she plans to get an emotional support animal. So we would have to wait and see if Tracy did submit her request for reasonable accommodation. Thank you for participating in that hypo. So moving along, we are going to delve into reasonable modifications as part of reasonable accommodations. A request for a physical change to the unit must be requested by the tenant, the resident, or somebody who is assisting them. The best practice is to put it in writing. And an example of a reasonable modification, which is pretty common, is for residents to request safety grab bars in the bathroom, in the tower, or in the bathroom, in the shower. And the rule is that the landlord is not required to pay for the modifications. The exception there is if the tenancy is subsidized by HUD. So Section 8 tenants in California would not have to pay to install the safety grab bars. But a tenant with a private landlord who is not subsidized by HUD would have to pay for the modifications. And there is a requirement that after the tenant leaves, if they, move out to some other place, they would have to return the unit to the same condition as it was before the modification. So again, a tenant with a private landlord would have to pay to uninstall the safety grab bar and, make the tub or the tile back to how it was. And again, the exception applies for tenants who are subsidized by HUD. They would not have to pay that. The landlord would have to pay for it. So that's reasonable modifications. And we have another hypo here. These are reasonable accommodation hypos. So true or false here. Someone with a mobility impairment can request a parking spot closer to their unit as a reasonable accommodation. I'm seeing lots of trues, true, true, true. Yes, indeed. This one is true. Number 2. It says, someone who has a severe phobia of spiders can request a parking spot closer to their unit as a reasonable accommodation. I'm seeing lots of false, no way, maybe, false. False, false. No way. So, I'm not going to say this was a trick question, but Alejandra and I did discuss this, and but okay, here's an answer, but maybe a parking spot with an overhang. Yeah, we did kind of brainstorm a couple of situations where a severe phobia of spiders could possibly be connected to an accommodation of getting a parking spot closer to your unit. So we said that's a maybe. If there's for example, if there's a large population of spiders between the parking lot and this tenant's unit, and there's commonly lots of spider eggs and spiders hatching all the time and webs and large spiders hanging all over the place, it may be that a parking spot closer to their unit would reasonably accommodate that tenant with the severe phobia to use and enjoy their dwelling as other people do. So that's a maybe. And number 3 is I have a severe phobia. Okay, so to the person with a severe phobia, I'll stop talking about the spiders. Number 3, a person with mental health impairment received a notice of lease violation due to symptoms of his or her disability. This person can request that the notice be withdrawn as a reasonable accommodation. True or false? This tenant has received a notice of lease violation. I'm seeing lots of truths. And yes, your instincts are correct. This is true. Absolutely true. I think it would depend on disability. Yes, that's always a factor. Someone put that in the chat. Definitely, always a factor. All right. Moving on. We have some additional common examples of reasonable accommodation with modifications. So a client needs a ramp to access entryway of their home. The reasonable accommodation could be to install a ramp. The client needs an emotional support animal, but pets are not allowed in the unit. Reasonable accommodation could be to allow for an emotional support animal. Client's source of income, SSI. The SSI check comes in every 6th day of the month of every month, but the rent is due by the 5th. A reasonable accommodation to change the rent due date. And a client's disability makes it difficult for them to move within the eviction notice period. We could request a reasonable accommodation for more time to move. So, how to enforce fair housing laws? An administrative complaint can be filed with HUD or at the state level with the California Civil Rights Department, that's CRD, or with the Department of Justice. Also, fair housing laws are enforced sometimes during the course of a defense in an unlawful detainer eviction in the eviction process. Additionally, civil lawsuits, where a tenant may file a civil lawsuit, receive money damages, or injunctions, which is a court order to one of the parties to stop doing something. And I'm going to move on to other tenant protections. So the eviction process is a way for the tenant to respond to the lawsuit and preserve their rights. So in the eviction process, an unlawful detainer is the legal wording for the eviction lawsuit. That's what it is. And a landlord cannot legally evict a tenant unless the landlord goes through this process. The first step of the process is that the landlord must provide a written notice to the tenant. A verbal notice is not valid. For example, if a landlord provides a tenant a 3-day notice to pay rent or quit, and the tenant has not paid after the 3 days, then the landlord is able to file the unlawful detainer eviction lawsuit with the Superior Court. Once the eviction lawsuit has been filed, the landlord in Contra Costa County must effectuate personal service. Commonly, landlords will hire a service process server to physically hand the paperwork to the tenant. After the tenant receives the eviction lawsuit, they have 10 days to respond. So this is very exciting news because this is a new law as of January 2025. Before 2025, tenants only had 5 days to respond. That's a very short time. 10 days is still a short time, but it's much, much better. And this is 10 court days. So that excludes weekends and holidays. So 10 court days, not including weekends or holidays to respond. Moving on to security deposits. This is another exciting update. This law went into effect July 1, 2024. Landlords can only require 1 month's rent for security deposit, and that's for both furnished or unfurnished apartments. The exception is a landlord may only charge 2 times the monthly rent for security deposits if all of the following apply. The landlord is a natural person or a limited liability corporation comprised of all natural people, not other corporations. The landlord owns 2 or less properties that collectively include no more than 4 units, and the tenants are not service members. So that's the exception there. I remember a time when landlords were charging 3 times the rent for security deposit. So this is definitely a very positive change in the security deposit law. Next up, we have source of income. This is a protected status. Oh, I see a question. What is a natural person? That means a person who's acting as themselves, not as a corporation or an entity or a trust. As of January 1, 2020, all landlords in California are required to accept Section 8 and VASH vouchers and other forms of rental assistance, and consider them as part of the applicant's income. So that means that if someone has a Section 8 voucher, that amount that Section 8 is providing toward the rent is also considered to be part of the tenant's income. And that's important during the application process when the landlord is going through the application to see what the total income is. Next slide. Thank you. We have a hypo here. Tina, tenant, is looking for a place to rent on Craigslist. She finds a listing she is interested in, but the listing states no Section 8 vouchers. She also has poor credit. Regardless, she applied for the housing, but is denied when they learn she has a Section 8 voucher. Can the landlord deny her housing based on this reason? A, yes, because source of income is not a federally protected status. B, yes, the landlord can deny based on her poor credit. C, no, because source of income is a protected status in California. What does everybody think? I'm seeing lots of C's, B's. B. B's and C's. Looks like answers are still coming in. B, all right. B's. So we have here C is the correct answer. Can the landlord deny her housing based on this reason? And the reason is she was denied because she has a Section 8 voucher. So the landlord cannot deny her based on this reason. For those who answered B, this was a tricky one because landlords can look at credit and rental history. But because this specific hypo says that she was denied because of Section 8, the answer is C. If it were flipped, if the landlord had instead denied her for poor credit, I think there could still be an argument that that's potentially a pretext to not allowing a person with Section 8 to become a tenant. All right. Under Assembly Bill 291, this is the Immigrant Tenant Protection Act. So landlords are prohibited from specific conduct. Landlords are prohibited from asking a tenant about their immigration or citizenship status unless it is to comply with the federal government program or other legal obligation. Landlords are prohibited from requiring a tenant or prospective tenant to make a statement, representation, certification, or certification about their immigration or status. Landlords are prohibited from disclosing any information relating to the immigration or citizenship status for purposes of harassment, intimidation, influencing a tenant to vacate, or recovering possession of the dwelling. And landlords are prohibited from retaliation, including reporting or threatening to report a tenant and or their associates to immigration authorities. Next slide, please. And we have another hypo. Tammy tenant rents a studio from landlord. She has a green card. During her tenancy, Tammy's studio required several repairs. She provided written notice to her landlord, but her landlord didn't respond immediately. After 3 weeks, her landlord stated that he would get a repair person out to her unit. After reminding her landlord, no one came to Tammy's unit for over a month. Tammy contacted code enforcement. Code enforcement investigated and ordered Tammy's landlord to make repairs. Tammy's landlord gets upset and accuses Tammy of being undocumented and tells her that she needs to vacate immediately and go back to her country. Landlord sends Tammy a text message threatening to contact ICE. True or false? Landlord engaged in unlawful discrimination. I'm seeing T's and true and true and true.
I just wanted to highlight really quickly that the protection we're talking about here is state law, right? So under state law, these are the things that are not permitted. So I want us all to keep that in mind in our context of understanding what protections we have under what laws.
Thank you, Alejandra. That's a really important distinction. So yes, the answer is true. Under state law, this would be considered discrimination. And this brings us to our case study. So there are 4 slides. We're gonna go slide one, we're gonna take each slide one by one. So, here we go. Tim and Teddy are looking for a place to live. They begin their search for an apartment with the help of a housing navigator. Some of the postings they find say things like, must be gainfully employed, or no Section 8, or only credit scores over 750, or no dogs allowed. The next day, their housing navigator speaks with property manager Pamela, who says she has an apartment available now. However, when the housing navigator tells Pamela that Tim and Teddy will be using rental assistance to pay for the first and last month's rent and the deposit, Pamela says she doesn't want to rent to anyone who cannot afford the rent without having to use rental assistance, and that the deposit would have to be increased to 4 times the monthly rent. So what issues do you all spot here? Security deposit 4 times, yep. Yep. Mm-hmm. Times the rent, increasing security deposit 4 times, yes. Denying. All right. Discrimination, unfair housing practices, yes. Yes, so here in the first paragraph, almost all of the above is discrimination. Yes, going through the first paragraph here, advertising in fair housing, we have a couple of examples here where landlords are discriminating in their advertising. Gainfully employed, that could be a disparate impact, could be discrimination based on disability or source of income. And no Section 8 vouchers, that could be discrimination based on source of income, and that would be considered intentional discrimination. Must speak English. Oh, I didn't actually have that in the section, but that would be national origin, discrimination about the language you speak, intentional discrimination. And the credit score, that's an example potentially of a disparate impact and also intentional discrimination. And then in terms of the second paragraph, where Pamela says she does not want to accept rental assistance payments for the first and last month's rent, that goes to source of income, and that is a protected status under California. Additionally, Pamela is, and this hypo is taking place in California, so we just learned that the deposit can only be worth 1 month's rent, except for the exception, which doesn't apply here. So Pamela would not be able to demand 4 times the monthly rent.
I just wanted to add also that when we're talking about like a blanket policy for the credit score, only credit scores over 750, I wanted to be a little bit more clear around how that could be disparate impact. And again, why that would matter. So if we're imagining that, let's say a domestic violence survivor experienced financial abuse, and some of this financial abuse included abuser taking out a bunch of credit cards under their name and not paying them, and that affected the survivor's credit score. If there were scenarios where domestic violence survivors experience that kind of financial abuse, which there are, then they would be particularly affected by this type of blanket ban that seeks to neutrally enforce a certain credit score, but really has an impact on protected status people, including domestic violence survivors. So again, the idea is that it looks neutral on its face, but is it impacting protected folks in a particular way? And while we said that under federal law, there's a shift to no longer enforce disparate impact theories, I do want to confirm that we have these protections that continue to exist under state law. So if you wanted to enforce this under state law, you still could.
Exactly. Thank you, Alejandra. All right, next slide. After some legal advocacy, Tim and Teddy are approved as tenants and moved in. Soon thereafter, Tim was involved in a car accident and suffered a spinal injury. He was able to walk, but only short distances. Tim's doctor provided him with a disabled placard so that he could park close to his destination. The only place Tim could not park close by was his apartment building. There were parking spaces in the complex, one of which was right in front of Tim and Teddy's apartment. Tim asked Pamela, property manager, if she could designate that parking spot for him because it is difficult for him to walk long distances and the spot is close to his apartment. Pamela told him, "You look fine to me. Plus, it is not fair if I give you a parking spot up front because there are other tenants who have lived here way longer than you that want that parking spot. If you want that spot, you need to pay for it." What issues do you all see here? Discrimination of disabled, reasonable accommodation, implying he's not disabled, yeah. Assumptions, discrimination, pay for the spot, lack of empathy, denying reasonable accommodation, pay for the spot. Like answers are still coming in. Accommodation or modification. Discrimination of disability and denying a reasonable accommodation request. Discrimination. Disability discrimination. Yes.
I just want
So,
to flag, there's one question in the chat about whether it's an accommodation or a modification. I don't know if you have any input on that.
yeah, that's a great question. I would say as a defense attorney, I would say it's not a modification. It is a reasonable accommodation. But I mean, I think that's an interesting argument to frame it as a modification. The modification would be that Pamela designate that spot for Tim.
Yeah, so,
Yeah.
so I think the easier way to think about the distinction between a reasonable accommodation and modification, and let me just jump in, is to say that a modification is when you're trying to physically alter some aspect of a structure, right, to meet your needs, whether it's a ramp or assistive devices. I want to think of it more as like a physical change. This could be a physical change if, let's say, it required constructing a ramp or some sort of accessibility thing related to the parking spot, or even like constructing a parking spot. But I think because we're talking about an existing parking spot and there's no construction or physical modification that's needed, it would be a reasonable accommodation request. And again, it's an important distinction because with a reasonable accommodation request, there's no cost that the tenant would have to pay to make that request. And here they would be asking that a space be designated specifically for them. That it should be something that the provider is charging them through a reasonable accommodation.
Thank you for that clarification. Yes, that's important, an important distinction. So yes, everybody was spot on. Sounds like there's some discrimination here. Um, the facts are that Tim was involved in an accident. He has a spinal injury, and his doctor gave him the disabled placard. Those are things that Tim could include in a reasonable accommodation. Here, he asked for a verbal reasonable accommodation, and he can follow up in writing and add the nexus, which is that due to my spinal injury, having a parking spot closer to my unit will help me to be able to walk into my unit. And therefore, he would have equal access to enjoy the dwelling. And the part about you look fine to me, housing providers should not be making decisions just based on physically looking at someone. It's about listening and reading the reasonable accommodation, engaging in the interactive process, and trying to come up with an alternative, if necessary, accommodation for the tenant who's seeking a reasonable accommodation.
I will add, though, that the law as it's written says that you only have to provide additional verification of your disability need if your disability is not apparent. And really, what that means is if it's clear, let's say either because you're in a wheelchair or you use assistive devices to walk, if that disability is clear on its face, then you don't need to provide additional medical verification of your disability need. So I do want to add that in as something that is important to keep in mind, but certainly where there are limitations around that is obvious in this sort of situation where property manager is making incorrect assumptions or just overall problematically analyzing the particular request a tenant's coming to them with.
Yes, indeed. And then the issue, oh, here we go. That's okay. We can go to the next slide. Later that week, Teddy received an email from Pamela stating that the property management's corporate office ran an audit and found that one of the required rental application forms was missing from Tim and Teddy's tenant application file. Pamela asked Tim and Teddy to complete the form called Getting to Know You. The form included questions such as, what country were you born in? Do you speak English? Are you married? How many children do you have? Do you have a disability? Are you a veteran? Tim wondered if he had to provide such personal information to the property management. He responded to Pamela's email declining to complete the form. Pamela replied that it is mandatory and if they do not complete the form, they will receive an eviction notice. What do you all think? What are the issues you see here? Are there any protected statuses? Country of origin, language, disability, marital status, children. Yes, all of those. Discrimination does not have to answer any. Yes, all of these things are true. This is discrimination on the basis, many protected statuses. Yes. Yes, it looks like everybody understands that these are all based in protected statuses. So we can go through each one. What country were you born in? So protected statuses, national origin under federal law. Good point. Pamela made it mandatory. That's really problematic too. And then for what country were you born in? In California, the protected statuses would be ancestry and immigration status. These are questions related to tenants' personal life and status, unnecessary for inquiry. Agreed. Going down these protected statuses, do you speak English? Under federal law, national origin is a protected status. And in California, immigration status, primary language, and ancestry are all protected statuses. Are you married? Federal law protects marital family status. And in California, we protect marital status as well. How many children do you have? Federal family status. Do you have a disability? Under federal, physical and mental disabilities are protected status. And in California, medical conditions are also protected status. And are you a veteran? California has a category for veteran status to be protected. So what can and can't the landlord ask? Landlords can ask for information on rental applications that help them assess a tenant's suitability, including their income, credit history, and rental history. They may also request references and background checks, but they should not ask about protected characteristics like race, religion, or gender. All right, we just have one more slide. Is common law relationships protected? I'm not sure about that. All right, last slide here. After some legal advocacy, Tim and Teddy were able to stay in their unit. They decided they wanted to adopt a rescue dog. They found a sweet dog named Daisy and brought her home. She seemed happy enough during the day, but each night Daisy continuously barked very loud. They received a call from Pamela that they are not allowed to have dogs per their lease. Tim called his doctor and requested a letter explaining he requires an emotional support dog because Daisy helps him when he goes for a walk, per his doctor's orders to do his physical therapy every day. He emailed the letter to Pamela right away. Pamela responded quickly and stated, Tim, you are not disabled, and per the lease, you cannot have a dog in your apartment. What issues do we see here? Denied reasonable accommodation. HIPAA violations, discrimination, reasonable accommodation was denied. Tell Tim he's not, yeah. Yeah, Pamela is pretty problematic in the way that she handles reasonable accommodation requests. So yeah, those are the key issues here. Number one, I would ask Tim and Teddy to double and triple check their lease. You know, is there really a prohibition against dogs? And the letter from the doctor that Tim sent, I think it would be the next step for them to ask Pamela to engage in the interactive process. If she denies them again, then at that point, Tim and Teddy okay, we have a good question here. So what is the reasonable accommodation when your dog is barking loudly? So I think the reasonable accommodation is not to be allowed to have a dog that barks loudly. Pamela is saying you're not allowed to have a dog at all. So hopefully Tim and Teddy would, invest in some training for Daisy so that she wouldn't be barking so loudly. But in terms of having an emotional support animal, that's what the reasonable accommodation is for. And Pamela just denied it right out without engaging in the interactive process. And so here's a reminder about how fair housing is enforced. So if Tim and Teddy were denied the emotional support animal, or they could potentially file a complaint with HUD or the California Civil Rights Department, which was formerly the Department of Fair. That was the previous department. It's now called California Civil Rights Department, or the Department of Justice. And if there was an eviction lawsuit, that would be another opportunity to enforce the fair housing laws. And if Tim and Teddy were to file a civil lawsuit, they could potentially receive money damages or an injunction, which would be an order from the court for the landlord to stop doing something. So ways to access our services again, our legal advice line in all practice areas. You can refer the people that you are serving to the phone number here we have Monday and Thursday, 9:30 a.m. to 3 p.m., Tuesday, Wednesday, 9:30 a.m. to 1 p.m. And now we are just going to open it up to questions.
Yeah, and then Jamie, you can start